Divorce is never easy, but what makes it even more difficult is if you believe myths about how the divorce process actually goes. One of the most common myths that I hear is that divorce has to be a bitter battle. Nowadays, many states have adopted programs where the parties can collaborate to try to work out their divorce differences without having to put them in front of a judge. You have court-sponsored programs where they will provide a court-appointed mediator to you, sometimes at no cost. And sometimes some states will offer programs where a retired judge or other judicial official will come and act as a mediator, sometimes also at no cost for you. And the parties can work out those differences without having to have a costly trial. Trials will often have pre-trial deadlines and lots of work where your attorney has to incur significant expense on your behalf before you even actually step foot inside of a courthouse for your trial. So if you're able to collaborate and work it out beforehand outside of the courthouse, then that would definitely be the way to go. Another common myth is that mothers usually get custody of the children in a divorce case. This comes from an old set of laws that were called the tender years presumption. Over the last 20, 30 years, many states have gotten rid of this presumption and now focus on what is called a best interest analysis. In some states, that's just a list of factors where the court will look at the age of the child, the mental and physical condition of the parties, if the parties have been encouraging contact between the child and the other parent, if they co-parent well, if there are siblings or other extended family members in various areas, if one of the parents wants to move. So that presumption no longer exists. What you would need to focus on in your custody case is making sure that you are providing the best environment for your children to thrive. And if you can show to the court that that's what you can do, then that's going to make your custody case that much easier. Lastly, one of the most common myths that I hear is that if the parties are in agreement as to all their issues, then they don't need an attorney. That just simply is not the case. I've had clients who have come to me with agreements that they have drafted themselves or with online services, which references laws that actually don't even exist. So instead of arguing over a divorce from the beginning, you're now arguing over how to interpret your agreements. You may forget certain tax implications, such as if you have a 401k account or other retirement accounts, and you need to transfer funds from one party to the other. If you don't do that correctly, then you may have unintended tax complications that you never wanted to have to deal with in the first place. Divorce is already stressful enough without falling for these common myths. If you're facing a divorce or other family law battle, consult with a legal professional to make sure that you're getting the most out of this difficult time. If you have any questions, we here at Melone Hatley are your partners in divorce and in estate planning. Feel free to give us a call and we'll be happy to help you any way we can.